Good morning, everyone, and thank you all for being part of this panel on lessons learned from state and local government cumulative impacts permitting experience. And this is a session I think that is a long time coming. Um, so the issue of cumulative impacts is seen as a truly transformative issue for environmental justice and environmental protection overall. In fact, many see it as the holy grail of environmental justice. Overburdened communities across the country, which have been disproportionately burdened by concentrated environmental impacts and noxious land uses, are saying no more. For many communities, the flashpoint of these issues revolve around environmental permitting. Therefore, it is a real honor and privilege for me to be able to moderate this panel today. The panelists here are key players in three history making developments for environmental justice, cumulative impacts, and facility permitting. Not only do they represent three key developments, I will submit that they, in fact, represent three important pathways for developing solutions and strategies and solutions for addressing cumulative impact and environmental permitting. Their stories begin to offer critical lessons for what makes for successful collective strategy and action to incorporate cumulative impacts in governmental decision making. So, if you can bring up the slide, I wanted to kind of give a little bit of a historical perspective on this. Um, Great. Thank you. So this slide comes from an article I wrote for the Environmental Law Reporter in 2021. And it kind of begin to think about, for me at least, to think about the fact that when we talk about environmental justice, there are multiple decision contexts that require different types of analysis, different scales and degrees of quantification, um, and that, in fact, and so for different types of decisions, and those different types of decisions are identified here along this continuum in terms of things like outreach and analysis or resource allocation, permitting, rules, standard setting, etc. And so the first thing I wanted to say is that we already have been using cumulative impact assessment to significantly influence or inform governmental decision making, and that comes with Cal EPA's Cal Enviro Screen, and I wanted to recognize them because of their role, which in this. Continuum of development around cumulative impact analysis. The Cal Enviro Screen tool is in fact helping to inform many other developments, including, I think, as you will hear from Megan, the current efforts in Chicago around the cumulative impact assessment. However, the really difficult part of this is to start to move into the no, so let me back up. So Cal Enviro Screen has been used to inform um, the allocation of resources and the ways that we can prioritize program attention and delivery. And so, and so this has been now being used to inform the allocation of not just millions but billions of dollars. But the hard part for this issue is moving into the regulatory space. And now we are beginning to see developers in that, beginning in 2008 with the Minnesota's cumulative levels and effects law and development of protocols, which you will hear about, New Jersey's landmark law and regulations, which was the law which was passed in 2020, and the Chicago Department of Public Health RMG General Iron Health Impact Assessment in 2022. And so we are going to hear speakers talk to these today. And like I said, I hope this begins to give us a basis to start a conversation about what makes for successful strategy and collective action in incorporating cumulative impacts into government decision making. So with that, I want to turn it over to Deputy Commissioner Sean Moriarty from New Jersey DEP, who helped to spearhead the development of regulations for the landmark New Jersey Cumulative Impact Law, which is the first law in the nation that requires mandatory denial of a permit if a new facility will disproportionate impact an already overburdened community. If you watch the voluminous recordings of all the public engagement sessions that Sean has conducted, you will not only learn a lot, but you will marvel, as I have, at his mastery of environmental law and regulations, his commitment to transparency, and his intense dedication to be true to the lived experience of communities. Sean?
Well, thank you, Charles. That is quite flattering. I can't believe you watched all of those presentations. I didn't even want to have to go back and watch them. So I'm going to share my screen and go through this, and really appreciate the opportunity to be here to discuss this today. So as Charles indicated, in September of 2020, Governor Phil Murphy from New Jersey signed the state's environmental justice law, which we think, the first of its kind and really a landmark change in environmental law in the state of New Jersey. And we now, as of August of this year, have officially proposed and adopted the regulations to put those rules in place. And it's obviously a huge accomplishment for us. And we're very, very proud to be part of this movement among the states and with the federal government to begin to address cumulative impacts in our overburdened communities, low-income communities, and communities of color generally. So, where the rules are really premised, and we'll talk a little bit about the data that we have, but our data shows that New Jersey's low-income communities and communities of color have historically been subjected to a disproportionately high number of environmental and public health stressors. That includes things like multiple sources of air pollution, as well as numerous stationary sources of pollution, while also facing deficits in open space, quality green space, tree canopy, adequate stormwater management. All the things that some of us who don't live in overburdened communities likely take for granted in our daily lives. So what we're able to do under the regulations and as empowered by the statute is conduct a comparative analysis to assess how certain facilities seeking permits to construct or operate in overburdened communities will contribute to environmental or public health stressors in that community in a manner that is disproportionate when compared to its neighbors. That's my shorthand of it. In conducting this comparative analysis, the law now empowers the department to consider environmental and public health stressors on a facility-wide basis. And that allows us to include elements that were not previously subject to certain of the department's media-based regulatory schemes. Most notable on this are mobile sources of emissions, mobile sources of air pollution, those that often result in PM 2.5 and other particularly concerning pollutants in these neighborhoods. And as we've seen, as we've gone through this analysis from a data perspective, is that those levels are higher, and the concerns related to those exposures are abundant in our overburdened communities. So really, to that end, the EJ law enhances our existing authorities and allows us to look much more broadly at a facility when we are engaging in permitting. And this is obviously a big step forward from an authority perspective to allow us to really get at some of the issues that are affecting our overburdened communities. So as we go through the rulemaking, I think it's important to ground ourselves in the legislative intent. And as you can see, it's expressed in the findings on the screen. What these findings really speak to is a legacy of inequitable siting of pollution-generating facilities in low-income communities and communities of color. It also speaks to the need to more equally share the burdens of our state's economic development, and then the need to correct this historic injustice through meaningful public engagement and under appropriate circumstances, placing limits on the construction of new and the operations of existing facilities. So that last part, the public engagement part and the placing of limits or conditions on these types of facilities, including in certain situations denying permit applications for new facilities, that's where the rules really focus. That's really the action we take under the rules. So we really want to kind of start with applicability, right? So while the law is extremely powerful, it's important to understand exactly where it applies, and we look at 3 criteria for that. First, the facility in question must be located in an overburdened community. Those are defined by the statute as being census block groups, a very finite unit of census data, as being block groups that have 35% households that qualify as low income, 40% of residents that identify as minority or members of state recognized tribal community, or at least 40% of the households have limited English proficiency. So that's the basis of our analysis, is looking at those overburdened communities. Then we consider whether the facility in question is one of the 8 types of facilities listed in the law. Now, those are mostly focused on large sources of air pollution, so your Title V, your major sources of air pollution, as well as the numerous types of solid waste facilities. And as we've seen, these are, in particular New Jersey, are often located in overburdened communities. And then considering other kind of sewage treatment plants. So that's kind of our universe of facilities. And then we're considering, as the third criteria, whether it requires a permit. And that permit is basically almost any individual permit from the department, those individual permits being the ones that require kind of a deeper level of analysis. From the department's perspective, we have general permits and permits by rule in certain of our regulatory schemes. But anywhere where a facility is required to obtain an individual permit that requires a more detailed review, in those situations, the department is empowered to review that facility under environmental justice regulations. So those are your 3 criteria. What's kind of important to kind of note here is that the law excludes authorizations or approvals necessary to perform remediation. So it doesn't work at as some would claim, cross purposes of actually addressing some of the legacy environmental contamination in these communities. It does not interfere, in quotes, with the ability to remediate these properties. It really focuses on what is the end use of a potential remediated property, and we don't want to continue the status quo of having properties kind of remediated to some extent, capped, and then turned into solid waste facilities after their previous industrial use. That's what we're trying to avoid. We're trying to avoid the continuation of those inequities. It also excludes minor modifications to major source air permits that do not increase emissions. So there is some flexibility here for continued operations. But what I also want to note here in terms of applicability is the rules apply to new facilities, expansions of existing facilities, and renewals of our major source permits, or our Title V permits only. If it's an existing facility that doesn't have a Title V permit, even if it is one of the facilities covered by the law, if it's seeking renewal of an operating permit that's below that Title V threshold, it is not going to ultimately be subject to the environmental justice regulations. So let's talk about what these overburdened communities look like in the state of New Jersey. You can see on the map, they're broken down by how they meet the different statutory criteria. The important thing to note here is that it covers about 4.5 million people in the state of New Jersey live within communities identified as overburdened communities by the statute. That's about half of our population. We continue to identify and update those maps. We'll be updating them on a yearly basis as new census data comes out. We want to make sure that we're using the most current data. But at present, through the development of our EJ mapping tool, or EJ map, we're able to show the location of all of the overburdened communities in the state, as well as individual stressor levels, which we'll discuss in a minute as we move forward here. So this EJ map, and I encourage folks who have spent any time with CalEnviroScreen or EPA's tools or any other tool to check our tool out. We're really proud of it. We think it does a lot, and it really does provide the baseline for the analysis that we need to conduct under the environmental justice regulations. So as we move forward, what we're really talking about is an identification and assessment of environmental and public health stressors. So the statute gives us these broad categories. We talk about environmental stressors. Those are concentrated source air pollution, mobile sources, contaminated sites, transfer stations, point sources, as well as public health stressors, which could be defined as conditions that may cause public health impacts. And that those things include asthma, cancer, elevated blood levels, cardiovascular disease, developmental problems. So two important notes here. First, it's always notable to me, and I do mention this every time, the presence of specific facilities. So those facilities that are covered by the regulations, those transfer stations and other solid waste facilities, those by the law are considered in and of themselves to be stressors. As we go through our analysis, we look for effectively an abundance of those stressors or those facilities in a given community from a density perspective to determine whether that is an actual adverse stressor. But the presence of those facilities, when in abundance as compared to the neighbors, is are by themselves considered a stressor, separate and apart from the other impacts that they might have on the environmental and public health conditions in those specific communities. The second piece to point out here is when we talk about public health stressors. One thing that we pushed for in the law, and we were fortunate to get, is language is the may cause language, right? So that what that allows us to do is use present conditions in data we have on present conditions in communities to kind of extrapolate into looking at things like asthma rates or cancer rates. It's very difficult for us in the state of New Jersey to access Department of Health data on, say, asthma levels or asthma rates in a given community at the block group level due to suppression issues, HIPAA issues, all of these other kind of privacy concerns. It's very difficult to use that information on that level. So by using the may cause language, we're able to really more effectively, we think, get at issues like asthma and cancer rates in ways that we would not be able to if we were using that health specific data. So that's been our approach here. As we went through the rules, then you have to kind of fill out that definition. We have to determine what stressors are we going to use to make this assessment. So we started with a broad list, 60 plus stressors, looked at the other available data. We looked at EPA, we looked at California, kind of narrowed that list down and landed on 26 stressors. In doing so, we looked at the alignment with the categories in EJ rule, again, concentrated source of air pollution, density, asthma, all of that stuff. The availability, quality, and the ability of our ability to use publicly available data at the appropriate geographic scale was kind of the second thing we looked at. So you need to have data that everyone can use, that everyone can access, and that can be used reliably and repeatedly at the block group level in order to be sufficient to make a regulatory decision. Again, regulatory decisions being something that are held to a higher bar than simply using it for a screening method. We really had to be careful in choosing those stressors. The second thing we did was look at marginal value. We wanted to make sure that we could add stressor upon stressor upon stressor. We want to make sure that the stressors that we added were meaningful. And ultimately, our stated goal here was to use the minimum number of stressors necessary to accurately assess environmental and public health conditions in the OBC. When we're putting the regulations together, when we're asking applicants and ultimately asking community members to make a reasonable assessment of impacts and to be able to articulate concerns, if we had 100 stressors, we were concerned that was going to become even more overwhelming than it probably already will be for some folks. So we wanted to make it tight, reliable, and ultimately implementable from a regulatory perspective. So in the PowerPoint, which we always share post this and is available on our website, we list all the specific stressors so you can kind of see that. I won't go through them given time, but you can see that we're using things like PM 2.5, we're using things like cancer risk, we're considering traffic, we are considering surface water impairments, density of facilities, we mentioned that being a stressor. We're looking at contaminated sites, we're looking at drinking water, potential lead exposures. We're looking at other things. We talked about deficits earlier. We're looking at lack of recreation space, lack of tree canopy, flooding, an abundance of impervious cover. And then we're also looking at kind of, our social determinants. We're using employment and education as being key determinants in that situation. So now that we've had kind of an opportunity to discuss what the stressors are, we got to kind of talk about how do you compare them, right? So I've kind of termed it the neighbors. From a more technical and regulatory perspective, we call it the geographic point of comparison. And the statute gives us is discretion to determine what the appropriate geographic point of comparison is. And what we ultimately landed on was a hybrid approach, which we felt was really the most protective thing. So what we're doing here in terms of comparing to an overburdened community to a non-overburdened community is considering the lower of any individual or cumulative stressor levels at the county or state average or 50th percentile of the non-overburdened communities. So what we're doing is comparing conditions in overburdened communities to those not considered overburdened by the legislature, and then making determinations based off of that. So for each of the stressors that we've identified, and ultimately kind of our combined stressor total at the end of the day, each of those is provided a value, and then you compare it to the state or county for that individual stressor or combined stressor total. If it's higher, it's considered adverse. And then we kind of sum up the adverse stressors, and then the rules kind of take you through different avenues depending on whether the stressors are adverse, whether ultimately a particular overburdened community is subject to adverse cumulative stressors. So let's talk about those terms quickly. So an adverse stressor, as we indicated, is a stressor that's higher than geographic point of comparison. So you're lower of county or state, non-overburdened communities at the 50th percentile. That's for an individual stressor. A facility's combined stressor total is the total count of adverse stressors in an OBC. So we said we started with 26 total stressors. If you went through all those individual stressors, did the comparison, and then totaled up the number of adverse stressors, that's your combined stressor total. So in the example we have here, 18 of the 26 stressors were considered higher. So then that combined stressor total is 18. We then take the combined stressor total, we compare that number to the lower of state or county to determine whether the specific block group is subject to adverse cumulative stressors. So where the OBC's combined stressor total is higher than the geographic point of comparison, it's considered to be subject to adverse cumulative stressors. So in our example, the OBC with a combined stressor total of 18, where the geographic point of comparison lower of state or county is 13, in this instance, I believe it is the state, the OBC is considered to be subject to adverse cumulative stressors. The point of doing all of this is to take that big list of overburdened communities, that 4.5 million people, that 3,500 block groups, and really try to focus on the areas in the state that are most subject to adverse cumulative stress, that are really the most stressed communities, right? So that's how we kind of take that big list, that 4.5 million people, and kind of try to narrow it down to make sure that we're focusing on the communities most in need, because frankly, the definition is fairly broad from a regulatory perspective. So when we receive a permit application, what we'll ultimately be doing for applicants and for community members is providing them with baseline information. And then what that is pulling from EJMap, our publicly available mapping tool with all of the data on the stressors in it. It'll let it'll provide a baseline of information for the analysis that everyone can understand. That would identify those stressors. It would look at what the geographic point of comparison is. It would identify the adverse stressors, provide the combined stressor total, and then it would indicate whether that community is subject to adverse cumulative stressors. If it's subject to adverse cumulative, there is more process within the regulations. If it's not subject to adverse cumulative stressors, our regulations focus on ensuring that it remains that way, that we're not by providing more protections to the adverse block groups, that we're not then ignoring additional environmental burdens placed on the block groups that are not yet adverse. We don't want to be at cross purposes, obviously, in doing that. So the goal of our process, right? The goal of all of this imperative analysis is to avoid what we term to be disproportionate impacts. So it's really to avoid contributions to adverse stressors or to create adverse stressors that will be higher than the average, right? So we want to make sure that we're not contributing to where there's already an adverse and we're not creating new adverse stressors. Where a facility cannot avoid a disproportionate impact, we then require them to propose measures to minimize their contributions to stressors or to provide, in certain circumstances, a net environmental benefit. What's critical here from a regulatory perspective, and as we look at what our conditions are going to be, is that we're following in all instances and on individual stressors and avoid first, then minimize, and then under certain circumstances provide benefit. We're not allowing for offsets. We're not considering de minimis contributions. We're not saying, we're not allowing a facility to say, well, I reduced all these stressors, but I raised PM 2.5, and therefore, on balance, I'm doing better. That's not the approach here. The approach is very stressor specific and requires an analysis of contributions to each of those stressors and measures to avoid, minimize, and in certain situations provide that benefit. So how do we get to a decision, and how do we engage with the communities? That's through the development of environmental justice impact statement and what we've termed quite purposefully meaningful public participation. We want to really be able to rhetorically separate that from public participation that folks have likely engaged in with the department in the past and found to be insufficient. We want to make sure that folks understand that this needs to be meaningful and direct, right? So the EJIS, or the Environmental Justice Impact Statement, it assesses the public stressors in the facility drawing from that baseline information, and it looks at the measures that the facility would propose to avoid or minimize those contributions, right? So it takes the baseline information, it analyzes the facility's operations and potential contributions, and then it asks the facility to propose measures. That information is then provided to the public and addressed as part of a public hearing held ultimately by the applicant in the overburdened community to walk through that information. Public notice in multiple forms. We've also, one of the things that we struggled with a little bit was how do you address community specific needs with regard to notice and to really ensure access, right? It was really critical to us. So rather than attempt to list out 100 different things we thought a facility should do to try to capture everything, what we're really asking facilities to do is to know their communities and develop community specific methods to engage, whether that is engaging with a specific community group, whether that is providing notice through through a local religious institution or otherwise. We really want applicants to meet their communities, to talk to them, and find out the best way to access them. Appropriate languages, appropriate methods to make sure that the people in the community know what is going on. Minimum 60-day public comment period. Applicants are required to respond to all relevant public comments in writing. So we're creating a robust record. We have environmental justice impact statement, we have public comments, and then we have responses to that. That's the record upon which the department ultimately make a decision. And that decision is where's the rubber hits the road. So we have had these regulations in place for approximately 2 months. We have yet to have to issue a decision under the environmental justice regulations. We're eager to. We're ready to apply these standards, but we've not yet had an application that goes through the process. So from the department side, once we have this information, we consider the environmental justice impact statement, testimony, written comments, and determine whether the facility can avoid a disproportionate impact. Where it can avoid a disproportionate impact, so it's not contributing to adverse stressors or it's not creating new adverse stressors, we would impose permit conditions necessary to ensure that that disproportionate impact remains avoided. So in most instances, a permit application that comes through this process is going to result in the imposition of certain conditions, regardless of what its impacts are. Now, the more challenging situation is going to be where a facility cannot avoid a disproportionate impact. So it's an existing facility. It's intended to expand where we don't have the right to deny those applications. We can only deny for new applications. What are we going to do? So for new applications where there's a disproportionate impact, we deny that application unless it serves a compelling public interest in the overburden community. That's going to be a very narrow exception. For expanded facilities or major source renewals, where we are only empowered as the department to condition those, we're going to need to authorize the applicant to proceed subject to appropriate conditions to address facility impacts, right? So that's where we get into what those conditions look like. So for renewals, we're looking again for avoidance and then minimization, where avoidance is not feasible, to contributions to stressors in the ODC. For new or expanded facilities, where you're going to by operation of the facility, beyond avoidance and minimization as those first two prongs, we're going to consider additional feasible conditions that will reduce offsite stressors or provide a net environmental benefit that improves baseline environmental or public health stressors in the overburden community, right? So you're going to get your full avoidance to the maximum extent feasible. Then you're going to get minimization for these types of facilities. Then we're also going to ask for more. We're also going to ask for more to improve conditions in the communities. We heard a lot from industry and frankly from our own folks, the need for specific standards related to your stationary sources, right? So, we have all of this, this body of law under the Air Pollution Control Act, under the Clean Air Act that addresses kind of, from a technological perspective, like what are facilities that have kind of stationary sources, what are they required to do to manage their emissions? So what we did here was we kind of modeled off that, something kind of similar to the state-of-the-art, standard to provide specific and what we hope are objective standards for those major source components, to really look at what technology they have to feasibly reduce their emissions. So in certain situations, we might be asking for emissions to be reduced below levels that would have otherwise been considered in the past to be protective of public health. We want to drive those down as far as possible. It might mean reducing some of your allowable emissions. It might involve taking certain outdated things out of permits to really kind of reduce the footprint, reduce the environmental footprint of a given facility. And we hope over a certain cycle of renewals, cycle of permitting, we'll be able to continue to kind of lower environmental impacts and ultimately remove hopefully some of the communities in our state that are considered overburdened at present, right, or that are subject to those adverse cumulative stressors. We're going to bring all of those levels down. So as we talked about, compelling public interest has always been a key point, and particularly for our advocacy community, something we really want to focus on because and I think what we recognized is this is the potential to create a huge loophole in the regulations. It's subject to mischief if not done right. So really what we wanted to do is create a narrow exception to the requirement that a new facility be denied where it cannot avoid a disproportionate impact. So where we define that is to really focus on essential environmental, health, safety needs of individuals in the overburdened community. And then we look at kind of an alternatives analysis. You got to show that the facility needs to be is essential to that, serving that need, and it also needs to be located there, right? It can't be located somewhere else and still serve that need. So we're asking them to go through a several tiered analysis to really get at the necessity of a specific project. What's important to note here, usually I underline on the slides just to really drive the point home, is that the need served needs to be the need of the individuals in the overburdened community. It's not a general need. It's not a general societal need. You talk about recycling, you talk about solid waste, like those all serve a need for everyone. But if this particular project that is seeking the compelling public interest exception is not directly serving the needs of the community, it is not suitable. So what we're really talking about here is a focus on public work type projects that are necessary to serve those individuals in the overburdened community, such that might directly reduce stressors. We have combined sewer overflows. There are going to be a lot of projects that potentially implicate the environmental justice rules in communities. Those projects that are going to ultimately reduce CSOs, reduce those overflows, reduce potential impacts to water quality and flooding. We want those projects to occur. We want them to be subject to the appropriate conditions. But this is the way in which those projects, to the extent they are otherwise subject to this rule, that's their path to move forward, is to seek a compelling public interest exception. Now, the other thing that generated a lot of controversy on our end was the exclusion of economic benefits of the proposed facility. That includes employment, tax revenue, ratables, all of those things. The rules specifically say we're not going to consider those as a basis to serve compelling public interest, again, to really avoid the creation of that loophole. So that's a very brief overview of the rules. I'm going to hang around. We'll have some Q&A later with the other panelists. I'm really excited to hear their stuff. But if you're interested, check out our website. We have all of this information, this PowerPoint, links to EJMAC, the rule, the whole thing there. And if you're looking to do this in any of your states or your local communities, please feel free to reach out to us. We're happy to provide our assistance. So thank you for the time, and thank you for the opportunity to be here.
Thank you so much, Sean, for that. And I think, when they say this is a landmark effort, I think, there's so much to, what has been happening in New Jersey that we can all learn from. So next we will have Megan Cunningham, who's the Managing Deputy Commissioner from the Chicago Department of Public Health, and Ellis Watkins from the Environmental Law and Policy Center. They are responsible, as I've said, for the use of health impact assessment to inform a permit denial decision in the RNG General Iron recycling permit case, and are building on that experience to develop citywide cumulative impact assessments, as well as an ordinance. And as part of that effort, or in addition to that effort, they're beginning to tackle the critical issue of zoning. When I invited Megan to speak, she said that CDPH wants to live by their core values of co-governance, co-design, and shared leadership and authentic engagement, and wherever possible, co-present with a community partner. So I will turn it over to you, Megan and Ellis.
Thank you so much, Charles. It is truly an honor to be with you all today, and particularly in the company of colleagues from New Jersey and Minnesota, to whom we owe a real debt of gratitude in this work. You all have laid a foundation for what we are attempting to do here in the city of Chicago. So we're going to spend just a few minutes today together talking about background on environmental justice in our city, which has really formed the basis for our deep commitment now to transforming the way that our city thinks about where and how development happens. We'll talk about our cumulative impact assessment process. And I think some hallmarks for us, as Charles has said, has been a real focus on how do we bring community voice and power into this work. And then also, how do we take a whole government approach, recognizing that my department is limited in the scope of our authorities and what we can do at the point of permitting or enforcement, and that if we're serious about changing conditions on the ground for environmental justice neighborhoods, it really takes a collaboration and a partnership with our city departments and sister agencies and all levels of government to advance some of the reforms and recommendations that our cumulative impact assessment will recommend. And then we'll wrap up with just some high-level lessons learned that may assist all of you as you are planning and implementing work in your spaces. So I'm going to turn it over to Ellis for some background on environmental justice in Chicago.
Thank you, Megan. I sound pretty clear to everyone? Great. So hello, everyone. Ellis Walton, Associate Attorney for the Environmental Law and Policy Center, and I also serve as the co-chair for the policy working group responsible for designing the draft ordinance that we plan on submitting. So, environmental justice in Chicago, just there's a long history of environmental justice activism. Chicago is the home of Hazel Johnson, who is known to some or to many as the mother of environmental justice. She was one of the first people, one of the first activists to highlight the burden of the cumulative pollution burden that communities of color experience. But she highlighted that through her experiences in Altgeld Gardens on the south side of Chicago, and just cumulative impacts and cumulative burdens has been a recurring theme, especially in the last few years in Chicago. The fight against receiving industry has been long fought, but in recent times we've started to finally see some successes in terms of changing the policy narrative and putting institutional power behind communities. Next slide, please. And so, like I said, the cumulative burden, one of the cumulative burdens that's been sort of highlighted in the last few years was the fight with General Iron, the relocation of an industrial facility from the north side of Chicago, the northwest side, all the way down to the southeast side. And as you see through this map, this shows this cumulative burden that communities of color in Chicago that they experience. The red is the more extreme burdens of pollution, and those south and west sides are the communities that bear the brunt of a lot of the industrial activities in Chicago, and those are the communities that we're trying to protect and to sort of remedy that harm that's existed for so long. And as I said, with the General Iron the fight against General Iron that's been taking place for the last few years, activists from different organizations that you see in this graphic were able to get the U.S. Department of Housing and Urban Development to sort of step in and get the city of Chicago to recognize the how permitting practices have sort of centered and distributed polluting activities in these south and west sides. And so the administrative complaint with HUD, we were able to have a settlement between the city, between the activists and HUD, and they were able to formulate this initiative to address this cumulative burden that communities of color are experiencing in Chicago. And that is this Chicago Cumulative Impacts Initiative. So right now we are in the cumulative impact assessment phase, and that phase is mainly just trying to understand the whole problem itself, looking at best practices and addressing the problem. And we then hope to transition into the policy phase in the next few months, where we have concrete policy of what we want to see for the city of Chicago, what we would like for the city to implement, and then we would go into the policy implementation phase. Next slide, please. So the goal of our cumulative impacts assessment is first to provide data on where pollution is coming from, how the burdens vary across Chicago, who receives those pollution burdens, and of course we know it's communities of colors. We also want to inform decision making in the land use, zoning, transportation, permitting, and enforcement processes that happens with the city, and in the way that the city agencies and departments function. We'd also want to, like I said before, co-design and lead this project with the communities who have been experiencing this overburden, this overburdened reality of pollution. And so throughout this process, we've been trying to make sure that there is parity between not only the city and its agencies, but also our community partners and technical experts and policy experts. So we could all use our skills, our power, and our reality to create a better lived experience for the most vulnerable communities. Next slide, please. And so this is just a timeline of our initiative. Last year, starting in May through December, we were sort of in the introductory phase where we are structuring the project. We are picking what sort of groups we would like to be a part of, and I'll get into the groups in a second, as well as researching researching best practices as well as looking for existing community input on what we like to see, what they like to see from us. And then we moved into our assessment phase where we then begin sifting out the different best practices that we like to see in Chicago. We then start to develop different methodologies and indicators to understand the burdens, the pollution, environmental burdens, and socioeconomic burdens that exist across the city. And now in September, we're looking at publishing all of our findings and policy recommendations for the public to view and to also inform the ordinance that we plan on presenting next month. So the structure of our cumulative impacts assessment initiative, we have, I would say, 3 subgroups, and those, or maybe 4. I might be wrong, but so the first group is the policy working group, which I co-chair. We are responsible for researching best practices for environmental justice and cumulative impacts initiatives nationally, and sort of synthesizing that information and presenting it to the broader group to inform our policy recommendations. We also have the community engagement working group, which is responsible for determining how we would like to engage with the public, how we would like to inform the public, as well as just overarching strategy of keeping the public involved and making sure that their input is reflected not only in our process of operating, but also the work product. And then we also have interdepartmental working group, which is a coalition of Chicago departments and agencies that work together to identify environmental justice policies that they can implement with their current statutory power, as well as an overarching project management team to just sort of run to serve as administrative executives of like managing the project. And these are our partners over here to the right as well. Like I said, we are a mix of government partners, community partners, and bigger green nonprofits, all working towards a common goal. Yes, and so like I said before, we've been trying to make sure that the community voice is centered in our approach, and that the policy recommendations that we propose ultimately reflect what the community, what the greater Chicago community wants from us, but especially the overburdened communities. And so we had 3 in-person sessions, I believe, last month and in July to sort of present what we're doing to the overall public, but also to solicit their feedback and to understand what they want from us, how we can do better, and what more do we need. And so that was successful. We had 3 larger in-person sessions, as well as different tabling events where we were able to explain to the public. And the city also hosted a public comment period in July, where they got feedback on the EJ departmental action plans, as well as our policy recommendations. So throughout the different community engagement events, we were collecting tons and tons of feedback. It was really good to just hear back from the community to see what they wanted from us. And they really enjoyed the fact that the city of Chicago came to them and really listened and had those hard conversations with them. A lot of people saw it as a first step, and something that doesn't usually happen, but it was great to see. And so we broke down the different themes of our community feedback The first was environmental justice focus areas. So that is just them wanting to make sure that we are prioritizing environmental justice areas over burning communities. The second was environmental health outcomes associated with pollution exposure, and that is making sure we're attentive to how the effects of exposure to pollution, how that creates chronic illnesses or influences the chronic illnesses in communities of color. The third is the socioeconomic impact associated with polluting facilities. So looking at that, looking at how the decision-making process is inequitable and leans towards industry versus community, as well as just overall general community recommendations that they would like for the city to implement to better the communities that they live in, or at least to better the experience and their reality. Next slide, please.
And I see we're getting a 5-minute warning, so I'm going to move us quickly through these next sections, and then we're happy to answer any questions. So what Ellis has shared with you is the process by which we conducted our cumulative impact assessment. We're meeting each other just a week or so too early because we are about ready to publicly release our Chicago Environmental Justice Neighborhood Map. But what I can tell you in sort of a preview mode today is that we have created a very similar index to the Cal EnviroScreen and work that New Jersey has done, where we have taken into account measures of pollution burden as well as population characteristics to create a map of Chicago so that we better understand where are the neighborhoods that are most vulnerable to the impacts of pollution. And these are the places where we intend to put in place these new policy protections. Like New Jersey and others, we will have a public-facing data dashboard and more detailed methodology documentation that we will be releasing by the end of this year and in early 2024. Another important deliverable of the cumulative impact assessment is our product of the Interdepartmental Environmental Justice Working Group, which included 12 city departments. So we had our teams working on transportation and land use and development. We had people from water management, from procurement services, who all asked themselves what they could do within the scope of their existing department authorities and with current resources to better protect environmental justice neighborhoods from harm. And so we have formalized all of this now in a City of Chicago Environmental Justice Action Plan that contains dozens of strategies meant to accomplish our citywide environmental justice goal, which you can see on this slide. Some specific examples coming out of this process are to expand our community hyperlocal air monitoring network in EJ neighborhoods so that we have better and more real-time data. Changing the way that we do transportation planning, and particularly routing of trucks in EJ areas, adopting strengthened industry-specific rules, making reforms to how the city conducts its contracting process, and adding environmental and health protections, particularly in city commodities contracts, addressing stormwater infrastructure in EJ neighborhoods, and many more. So this is how we're attempting to really model taking a whole government approach now that we have better data about where environmental justice neighborhoods are in Chicago. We see this as an important step forward in terms of strengthening those local protections. And then, of course, all of this is really building towards ultimately ordinance change for the city. And so Ellis has shared with us some detail about how we conducted national landscape scan and research on places like New Jersey and Minnesota and California and others to really identify 3 main areas of policy action. We call these environmental justice fundamentals, cumulative impacts elements, and community benefits. The target here is to create new standard governance systems and structures within the city of Chicago that create formalized advisory bodies that contain representatives from communities that are affected by EJ issues, that give them power in decision-making, that strengthen community engagement standards, and that formalize the cumulative impact assessment and allow us to apply it in how the city conducts its business. With cumulative impact elements, we are intending to move in the direction of other jurisdictions in requiring the city to consider a broader host of environmental, health, and social stressors in decision making. And we do intend to do that at both the point of zoning as well as the point of permitting. We find that we do have more flexibility in the kinds of requirements that we are able to impose upon businesses or authorities to deny permits at the point of zoning. And we think it is important that as we are conducting land use planning with an eye towards addressing cumulative impacts, that is a site of really initial engagement and point of intervention. Like New Jersey, we will be establishing thresholds that will be applied in our decision making based on impacts. And then we are also very focused on not just how do we minimize burdens, but how do we create benefits for people who live in EJ neighborhoods. So policy recommendations and what we hope to advance soon here in Chicago are the establishment of funds that can be used specifically for these areas on locally determined projects that can create local wealth, that can create local green infrastructure, that can promote neighborhood resiliency. And we do believe that communities should have agency and ownership over these benefits. Very briefly then, some lessons learned. You've heard us repeat this a number of times in today's conversation, but leadership with our values of being affirmatively anti-racist, focused on equity, accountable and transparent, and recognizing that a process takes a lot of time because it is really about building trust and repairing harm. We've really emphasized this whole government approach so that we can tackle comprehensively the root causes and drivers of cumulative impacts. We are really trying to incorporate this sort of lived experience data as data in the cumulative impact assessment and to think about ways that ground truthing continues to play a role in this work. And finally, a place where community members and industry representatives certainly have agreed in this process is that they expect policies to be clear, that minimize the administrative burdens, and that are applied consistently and fairly. And so our goal in this next phase of work as we move from policy recommendations to implementation is to ensure that the rules of the road are clearly communicated and understood by all of our stakeholders. If you'd like to learn more, you can visit our website, chicago.gov/cumulative impact. There will be a lot more there next week, so we encourage you to continue to follow along and feel free to reach out to us with questions. Thank you so much.
Well, thank you, Megan and Ellis. What a great presentation. There is so much going on there. I told the staff of CDPH that what they were doing is really making history. So now we are going to go to our last set of speakers, who arguably should have been first because Christy Alexson was responsible for writing the first ever set of protocols for assessing cumulative levels and effects for air permits as a result of the 2008 Minnesota legislation. She is presently working for the Union of Concerned Scientists, doing research on how to better incorporate community experience in the community knowledge and experience in cumulative impact assessment. She will be joined by her community partner, Sasha Lewis Norell. They not only will provide details about the early efforts, but reflect on what they have learned from New Jersey, Chicago, and other places to advance current efforts to advance cumulative impacts in the state of Minnesota. So Christy and Sasha, I'll turn it over to you.
Can you see my screen?
Yes, but you should put it on.
Yep. Okay, so I'm going to start, again, Christy Alexson, Union of Concerned Scientists. I'm going to talk through an older law, and then Sasha is going to present on the current work for the new law that passed this past legislative session in 2023. So thanks for joining us. Happy Tuesday. You know, the situation we're in right now and the state of Minnesota, specifically you're looking at the city of Minneapolis, is no different. There were racially biased systems that put communities of color in proximity to high sources of pollutant burden. And that wasn't, you know, it wasn't a mistake. It was on purpose. It was an intentional system that was set up. And you can see that that carries through to the present. We still have these high proximity proximity of high pollution burden near communities of color and low income communities in the city of Minneapolis. And in order to alleviate this situation, it requires system change. And I believe that cumulative impacts laws, ordinances, and rules are one of those systems changes that could potentially alleviate this situation. So in early 2008, I believe, there was a proposal for a biomass combustion facility to create steam and electricity in an already overburdened neighborhood. And there was a lot of opposition to that proposal. And part of the opposition built up support for a law that was passed, I believe, in 2009. I'm sorry if I'm going to get my years incorrect, but so passed in 2009. The wording of the law itself specifically addressed permitting, was related to permitting, specifically air permitting, possibly solid waste permitting and other types of permitting, but mainly air permitting, and required an analysis. The analysis had to look at the context around a facility. And it required that analysis was considered when the permit was considered. So that is the decision-making language we were working with in 2009. So an air permit engineer and myself were tasked as staff at the Minnesota Pollution Control Agency at the time to develop a method, do communication around it, get feedback from the community and so forth, and then implement the method with the first two permits that went through in this area. And I should say it's a state statute. It's a little unique. So it's a state statute, but it only applied to an area of South Minneapolis. And that was done through negotiation in the legislative session when it passed. So what we did is we set it up with the tools available to us at the time. California, just to give you a state of time, California was developing EJ Screen. So we were watching those webcasted meetings where they were defining cumulative impacts and developing EJ Screen and so forth. It was an exciting time. So we set it up with the tools that the agency had at the time, the air pollution computer modeling to look at all the emissions from an air emission source, and then estimate levels nearby at the fence line or out, to look at levels of air pollution concentrations, and then estimate health effects. So it was that old school classic paradigm of risk assessment. So then we would look at the pollutants that came from a facility that was under this law. And if they were over a certain level, we would include them in the analysis. The levels we set were 10% of toxicity values that we were using at the time, or a level lower than one of the criteria pollutant standards. Okay, so each of those pollutants, so now we have a bunch of pollutants that are included in the analysis, but it has to be cumulative, you remember. So we looked at the health endpoints that were aligned with those pollutants, and that's the way we pulled in the cumulative data. So those other public health stressors, social adversity stressors, other chemical stressors. So we looked at the health endpoints. Health endpoint, what I mean is like a respiratory irritant or a carcinogen, et cetera. And any other type of data that was publicly available at the time, accessible to us, we pulled in as a part of a report. And then that report was used in the determination of the permit. Okay, so that was our process at the time. Lessons learned from this process. One of the things we built in were information sessions before agency technical review. And that was uncomfortable at the time, but very important because it helped provide an informal setting where you sit down and you talk about the process. What's going to happen? Who are the people reviewing the work? What else should we know about the neighborhood? What other data might be available? We scoped by pollutant and health endpoint. That joining by health endpoint worked for us at the time. We got permit limits to avoid more analysis. So that was a win of that older law. So some facilities would take permit limits to avoid, say, having a certain health endpoint carry through and, be required to pull in data around that health endpoint. And at the time we didn't have the cumulative impacts in the EJ online mapping tools like they have now. I was literally emailing the health department to ask for smollett gestational age data or asthma data. And now Minnesota has a really nice public health data tool and some more environmental justice type screening tools available to them. So that was what we were doing then. And I think one of the benefits of that early law was it required decision makers to see a facility context outside of maybe that process flow diagram or whatever you're used to looking at, or the applicability of different rules. You were seeing the neighborhood. You were seeing the facility not as isolated, but in the context of the community. Challenges to fix, and this is where we're going to transition to the new law. There was no definition of cumulative impacts provided. We use the intent of the legislative authors, and we use the words of the law to develop this analysis. So we did a lot of inferring, the decision-making criteria was consider. It was not a priori. It was not direct. It was not the comparative analysis that New Jersey is working on right now, which is very intriguing and seems very actionable. We did not at the time include community engagement in scoping. When we had those information sessions, the analysis was already drafted. So we didn't set up a process at the time to allow community members to talk about maybe health endpoints they were very concerned about or saw a lot in their neighborhood. And that's a regret. There was no data tool. Like I said, if you have a data tool like an EJ map, you're maybe, 55% of the way there. And there was no permit denial or limiting authority. And now I am going to stop talking, and Sasha is going to start talking about the new law.
All right. Thank you, Christy. So I've got about 4.5 minutes to get through this, so I'll go quick so we can have time for Q&A. So as Christy said, this law passed earlier this year in the 2023 legislative session. It was the culmination of a number of years of work. Back in 2018, the local group Community Members for Environmental Justice brought this up again with the hope of expanding on cumulative impacts, both work that had been done previously that Christy mentioned, and also being inspired by work that was being done in places like New Jersey. Wanting to expand this kind of work to, at the very least, North Minneapolis, which is another very overburdened community, and hopefully also cover places across the entire state. So in terms of the law that was passed, it does have some limitations as well, especially given the pretty severe political divide between urban and rural Minnesota. And so this law covers environmental justice areas with the same definition that New Jersey uses in terms of census tracts, using the same criteria, but it only covers the 7-county metro area, so the Twin Cities area, as well as Rochester and Duluth, the two other largest cities in Minnesota. And then the tribes are able to have this impact their land as well if they desire it. It's a bit complicated there because they are sovereign nations, so they usually go through the federal government, but they would be able to use methods similar to what the MPCA is going to be using for this law. This law also covers, a lot of the same air permits in terms of it focuses on, a lot of the larger air permits that are actually having an impact on the local health or environment of communities. It also covers both new and existing facilities. And so it's basically whenever a new facility or a facility is expanding or getting their permit reissued, they would potentially have to do this cumulative impacts analysis. It also covers facilities that are not just within the census tracts themselves, but are within 1 mile of those census tracts, because we know that air pollution does not just stay in one area. And if a facility is, right next to a census tract, then we want it to be able to have this analysis done in case that it is harming one of these areas. And then the way that our permit denial works is it will define within rulemaking substantial adverse impact. And then if a facility meets that criteria, then it would either have to have its permit denied or it would enter into a community benefit agreement. And this is an area that we had been pushing for language that was similar to New Jersey in terms of meeting a compelling public interest, but a community benefit agreement is the language that was ultimately decided upon during the legislative session. And so a facility would do an analysis if they meet criteria of certain benchmarks. So that's part of the scoping where we're really targeting like the medium and large polluters, and also targeting facilities that are in like very overburdened communities. And so during rulemaking, they will lay out these criteria for when a facility must do this analysis. And then they would, do a similar analysis to what like New Jersey and other places do, looking at a lot of the context. That part is still being laid out within the rulemaking itself. And if it meets that criteria of substantial adverse cumulative impact, then it would either have to be denied or they would have to enter into a community benefit agreement, the process of which will also be defined in rulemaking. And with that part, we're really trying to highlight that community members should be able to determine if they want a facility to be given that permit and to enter into a community benefit agreement. Next slide, please. And so the rulemaking started earlier this year in July and will go as a deadline of May 24th, 2026. They're currently doing public engagement starting today. Well, they started with a comment period, and they're also having public meetings starting today with a number coming up this month. And then most of next year will be really the rule development process. We're really pushing for the agency to bring community members and community leaders into the process and to, work collaboratively to create this rule in a way that will strike the balance of adding additional protections and also empowering communities and, giving them the tools to either reject permits or, if they're going to be taking on additional pollution, then making sure that they are really getting the benefits and that they, agree to that because they want those sorts of benefits. Next. And just to quickly wrap up with the lessons that we learned, we had a lot of different organizations that were involved in pushing for this, and it took a number of different years. I think that we could have also done better with like building power across the state. A lot of our organizations are primarily based in the Twin Cities, and that made it more difficult to push for this law to cover the entire state. But we did have really good rapid response in terms of being able to respond to the how quickly our legislative session moved. We had strong legal support to make sure that the language that was passed, was very clear on exactly what needed to be done. This is a lesson that we learned from the previous law in 2009, where again, like a lot of that language was pretty vague and required a lot of rulemaking for interpretation. And we also wanted to make sure that we covered existing permits and facilities because, this is a law that should, stop new sources of pollution and also reduce current sources of pollution. And for challenges ahead, we need to set these benchmarks in a way that, covers the right facilities and make sure that certain facilities are having this analysis done and that also has a reasonable benchmark for permit denial. That community benefit agreements are going to have clear terms that will actually benefit the direct community, and that community can also reject those terms if they feel like they're just not worth it to take on that additional pollution. And also doing our best to make sure that community members are given the resources that they can properly engage with this process that has often been very exclusive, because this is again a process that we want to make very community led and make sure that they are being brought intentionally into this whole process. And I think that wraps everything up for us.
Great. Thank you, Christy and Sasha, and I guess a huge round of applause. I guess some way of doing that for all these presentations. I think that this is really a snapshot into history being made, and I think we're going to ask people to ask questions on the chat. And so as I'm waiting for them, I wanted to also note that Laura August and Walker Whelan from the Office of Health Impact Environmental Health Impact Assessment from California EPA is in the audience. I have wanted them to say a few words just to make sure we all understand where a lot of this came from. But I don't think that's possible. But in any event, I want to make sure you all recognize the role and the place that Cal EnviroScreen played in the historical development of cumulative impact assessment. So I know the first question we'll be fielding is the chat is for Deputy Commissioner Moriarty. Did I catch that? I don't see a question there. Okay, I have one for for Sean, and this is something I've been thinking about a long time, and I think one of the hallmarks and something that's not yet appreciated is that in New Jersey they're not really doing quote unquote cumulative impact assessment in the traditional sense. They're doing a disproportionate impact analysis in a cumulative manner, and so Sean, what do you think? The idea that you're required to have equity be a consideration. What role do you think that played in your being able to do the analysis that you've been able to develop?
Sure. Yeah. No. That's a. I like the way you termed that, Charles. I'm going to start stealing that now. Disproportionate impact, cumulative component. So I think when the law was signed and as we were negotiating it, I think as we looked at some of the other tools out there and began to consider what would make most sense from a regulatory perspective, what we really wanted to do was try to simplify the analysis as much as possible to insulate from challenge. Right? We're being sued on the rules as they currently exist anyway, so I'm not sure how much insulation we provided, but from a process perspective and from a reliability perspective, we tried to kind of stay away from weighting, stay away from kind of some of the other hallmarks of like a true cumulative impacts analysis. In doing that, we engaged really deeply with our stakeholders, particularly kind of our prominent environmental justice advocates, Nikki Sheets, Maria, Anna Batista, like Kim Gaddy, like some folks who are been steeped in this and ultimately are as responsible as anyone, including the legislature, for getting this law passed. We kind of engage with them on what makes sense from your perspective to get at an equity, to get at kind of an accurate comparison. And where we really landed, and I think some pretty detailed conversations with Dr. Sheets, landing at that kind of 50th percentile as being the key part of the comparative analysis, pushing that down as low as possible to maintain consistency with the statutory requirement that we determine where stressors are quote unquote higher than. We think that when you apply that, pick the correct number of stressors, and then kind of stack them the way we stack them, I think you get at really robust coverage of overburdened communities in the state, while allowing us to really focus on the ones that are most in need of those additional protections.
Great, thank you, Sean. I wanted to kind of pursue the same line of question quickly. This is for Megan and Ellis. I know that the cumulative impact assessment process in Chicago took place with the idea of Healthy Chicago 2025, which is seeking to ensure that equity is being considered. So how do you think that played in the way how did that shape your thinking in terms of developing or doing the health impact assessment and future and further activities?
Yeah, thank you for the question, Charles. And maybe I'll answer it in a way that touches on some of the questions I see in the chat as well. So Healthy Chicago 2025 is really about how we address the root causes of health to create optimal conditions and environments for people to live healthy lives. And a big part of that is about community power and capacity building. And so as we have thought about equity and outcome, we have also thought about equity in process. And that's why it was so important to us to share with you the journey that we've taken with our environmental justice organization partners. When we think about equity and outcome, I see some questions in the chat related to why we're creating our own Chicago-specific tool and not just relying on sort of state or national resources, which are becoming much better over time as the field advances. I think the answer to that is sort of twofold. One is, again, that the process mattered, right? We wanted our community partners, our government entity partners to feel real ownership over the data. And so we wanted to be able to choose the burdens that mattered most to our neighborhoods. We wanted to apply hyperlocal data sources, including an annual health survey that the health department administers here in the city of Chicago. And we wanted to really design the methodology together and then create mapping tools that followed from that. So it was really in that spirit of community co-design and co-ownership. And with an eye towards then how we make sure that we're capturing the right variables to track progress over time. I see also a question about the measuring the public health co-benefits and whether we have identified measures of positive impacts. We do intend to create an EJ scorecard for the city of Chicago. Again, kind of looking at some of these national models, our interdepartmental environmental justice group will be working with our EJ collaborators to identify those measures and to track them publicly and transparently as part of our commitment to ongoing accountability to not just reducing burdens, but also showing long-term public health benefits and outcomes. And much of that will live on our website, the chicagohealthatlas.org. We can put that in the chat if any of you are interested in seeing kind of how that module is being built out over time.
Great. Thank you, Megan. Yeah, and I want to apologize. I didn't realize I had to move over to the comments box in order to see the questions, so I overlooked them. One of them is from D. Williams, and it is for Sean, I think. What are the strategies that you use to get legislators on board?
Sure. So, I mean, first and foremost, our law comes, as I imagine many states and local localities. It comes, after years and years and years of efforts by our environmental justice advocates. And I think that, that's the first thing. It's a decade plus in the making to get us in a position to even have a law to pass, right? So, like, the first, that is the primary thing. That's how you get them on board, is continued direct and frankly untiring advocacy. From the department's perspective, I think there were two specific things that helped. One, we understood that this advocacy was happening for a long time. We had folks in our building who had done some of the legwork and the groundwork on our side to begin to conceptualize and visualize what a comparative impact analysis would look like for the state. So we were able to, as part of that legislative process, demonstrate certain things about, taking specific facilities, looking at them on a density basis, making those points of comparison so folks could see what the specific definitions and standards that were being proposed would actually look like for the state of New Jersey. I think that was critical, having that data ahead of time. And the second piece, and I think the biggest point of negotiation between the business community and the legislature and the advocates in the department was around what the department's specific authorities would be with regard to new facilities versus existing facilities. We, the original version of our bill, would have required a denial for renewals of existing facilities. That ended up being a fairly significant and meaningful give back, in quotes, to the business community to address some of their concerns about the continued ability for facilities to operate. Right. So taking that from a denial to a condition, I think really kind of addressed the last, like, really, really critical concern on their end and took away a lot of the steam that they would have had from an oppositional perspective. We have the ability to put significant conditions in. The business community is now mad at us for putting too many conditions in, right? So we've done our job in some way to try to make that really meaningful from a regulatory perspective. I think the last thing to say is that just the political climate at the time in summer of 2020 was ripe for action, right? And we were fortunate in some way that the legislature was positioned as a result of this advanced advocacy to be able to take a meaningful step forward in environmental justice.
Thank you, Sean. And I think we're getting close to the end of the session. So I just wanted to pose this question to Christy Ellickson. And Christy, you said that the idea of being able to do a comparative analysis was really intriguing to you, and so I just wanted you to talk about from the context of your experience with MPCA and the Minnesota regulations. And in your general knowledge of the issue, what did you mean by that?
Well, I think we're trying to address disproportionate impacts and burden. And so you have to have a comparative analysis to do that. It just is inherent in the question. And so you're trying to lower these, to decrease these gaps and lower what's already there. Those two things. You don't want to add more to already overburdened areas, and you want to decrease what's there. And so I think it's hard to answer that question because it's just so clear to me that it's necessary. Does that make sense?
Yeah, I think, I think one of the things, I mean, so I just speak for myself. I think, New Jersey's approach has been a real gift to us because what it does is it speaks to so many of these questions about the nature of the cumulative impact issue. But because they're able to do a comparative analysis, it gets to be a result that could be actionable. And if there's one message I would like to leave with everyone in thinking about, what this conversation means for lessons about what makes for successful cumulative impact assessment and action, it is that's one point that I would want to leave for people to reflect on. What I would call the requirement or the mandate to consider equity as part of the assessment process, I think is a really, really key strategic idea. And so, one of the things I would leave with people is that Columbia University Sabin Environmental Law Center has come out with a set of model legislation around cumulative impacts. And, New Jersey's, of course, was one of those they mentioned, but I don't think yet that we fully understood why that's the case. So, so I just want to kind of leave that in terms of my own editorial comment at the very end of the session. I want to thank the everyone for participating, and I want to really thank the speakers today. I know there was a lot of enthusiasm about this session, and it is because of the work that they've been doing that really is giving us, some pathways forward that we should all reflect upon. So thank you so much for being part of the session. A round of applause again for our speakers, and I wish everyone a wonderful afternoon. Take care.
Thank you, everyone. Thank you, Charles.